Have you ever stopped to think about that real tension between the state wanting to protect kids and a family's basic right to just be together?
Yeah, it's a constant balancing act.
And it often happens quietly, behind the scenes. And sometimes, even when people mean well, those fundamental rights can just sort of fade away.
That tension is exactly what we're digging into today. We're focusing on a specific legal thing, preponderance of the evidence.
Okay.
Especially how it's used when the state is trying to terminate parental rights. And our guide for this is Dr. Christina Christopher Laster's work, When the Scale Tips, Dismantling Parental Due Process. It's really insightful stuff.
Right. So our goal here, our mission for this deep dive is to really unpack how that legal standard, plus some other things, really impacts a parent's due process rights, especially for families who might already be vulnerable. And Dr. Laster, she puts it really strongly. She argues this whole system has, in her words, legalized the quiet dismantling of the Black family. Yeah, she sees it as state power hiding behind legal euphemisms to erase a parent from their child's life. Pretty heavy framing.
It absolutely is.
So let's get into the core of it. Dr. Laster says a big part of the problem is this legal bar, preponderance of the evidence. Right? The lowest bar you can have in court.
Exactly.
Right?
Think of it like, is it just slightly more likely than not? 50.1%. That's basically it.
Which seems incredibly low for deciding whether to take a child away forever. You'd think it would need to be much more certain, like clear and convincing evidence.
And you'd be right to think that. This isn't a new worry. The Supreme Court actually tackled this head-on back in 1982.
Okay.
The case was Santosky v. Kramer, a landmark decision. The court explicitly recognized the fundamental liberty interest parents have.
Right, the right to raise your own kids.
Yes, their care, custody, management, all of it. And they said this interest doesn't just vanish because maybe the parents weren't perfect.
Makes sense.
So, crucially, the court said using that low preponderance of the evidence standard to terminate parental rights. Unconstitutional. They mandated clear and convincing evidence instead. They got how serious and permanent losing your child is.
Okay, so Santosky set a clear standard, a higher bar. But if that's the law from the Supreme Court, why is Dr. Laster arguing that state courts are still finding ways around it?
Well, that's the disturbing part she highlights. She says many state proceedings use procedures or, interpretations that kind of subtly chip away at that constitutional protection.
How so?
She points to the judges. Many are appointed, maybe politically insulated, and she argues they can end up acting like extensions of the very same government agencies that are trying to break up the family.
So less like neutral arbiters and more aligned with the state's case.
That's her argument. She even calls them de facto prosecutors sometimes, operating in what she describes as a closed arena.
The closed arena.
Yeah, where it's the state social workers, the court-appointed lawyers, the judges. They all kind of operate within this shared system, this institutional culture.
And the parents.
The parents, she says, especially if they're poor or from marginalized groups, they walk in basically presumed guilty already. That's the dynamic she describes.
And what does that mean practically? She mentions the lack of a jury, right? And not much public scrutiny.
Exactly. No jury in most of these cases. Limited public accountability. So she argues it makes it easier for judges to just rubber stamp what the agency wants.
Because the law, or maybe the procedures, let them.
Right. And when that burden of proof is so low, just preponderance termination isn't this huge constitutional hurdle. It becomes more like, bureaucratic routine, just part of the process.
Around the exception it should be.
Precisely. And, the Supreme Court itself warned about low standards way back in '79 in Addington v. Texas.
What do they say?
They said using a standard like preponderance suggests society has, quote, minimal concern with the outcome, and that the parties involved should basically share the risk of a mistake equally.
But how can a parent really share that risk equally? Especially if, like Dr. Laster says, they're often unrepresented, uninformed, and often unheard.
That's the critical question, isn't it? It seems inherently unequal.
So, okay, navigating that low legal bar is tough enough, but then doing it without a lawyer, that just sounds almost impossible. This brings us to the next piece, legal representation, or the lack of it.
Yeah, this is another huge factor. And again, there's a key Supreme Court case here, Lassiter v. Department of Social Services from 1981.
Okay, what happened in Lassiter?
Well, the court ruled, and it was a close one, 5-4, I believe, that poor parents do not have an automatic guaranteed right to a court-appointed lawyer in these termination cases.
Wait, really? No guaranteed lawyer when you might lose your child forever.
No automatic guarantee. The court didn't say never, but they didn't say always either.
Wow. That paints a really bleak picture. You're standing there, alone, facing experienced government lawyers, maybe expert witnesses, and your kid's future is on the line. Dr. Laster says for many parents, Black, disabled, poor parents, that's not theoretical. That's the actual courtroom reality.
It is. Now, the court in Lassiter did say parental rights are, quote, far more precious than any property right. They acknowledged the significance.
What?
But ultimately, they kicked the can down the road. They said the decision about providing a lawyer should be made case by case.
Which creates
What Dr. Laster calls a patchwork of injustice across the country. Some states or counties might provide lawyers more readily, others hardly at all. It's inconsistent and often inadequate.
So let's connect these dots. You have this low standard of proof, preponderance.
Right.
And then you have many parents facing this without guaranteed legal help.
Exactly. And Dr. Laster argues that this combination basically guts the 14th Amendment's promise, the one that says the state can't deprive you of liberty without due process of law.
Because how much process is really due if the standard is low and you have no guide?
Precisely. And she points out this hits hardest on families who lack social capital, money, political clout, the ones least equipped to fight back.
She doesn't mince words about this, does she? Calling it institutional betrayal.
No, she doesn't. She frames it as fundamental rights emergency. She sees it as that urgent.
So given that urgency, what does she propose? What's the solution?
Right. She issues a very clear call for action. She lays out 4 key things that need to happen.
Okay, what are they?
First, codify clear and convincing evidence. Make it the absolute, non-negotiable national standard for all termination cases. No more loopholes or low bars.
Makes sense. Higher standard everywhere. What's second?
Second, guarantee legal counsel. Every single parent facing state-initiated termination gets a lawyer and an advocate they choose if possible. No more case-by-case uncertainty.
Okay, guaranteed lawyers.
Third, require specific training for judges. Not just any training, but independent constitutional training focused on preserving families, not just aligning with the agency or politics.
Interesting. Focus on family preservation. And the last point.
Finally, expose these decisions. More transparency. Make family court rulings subject to public reporting and appellate transparency. Shine a light on what's happening.
So higher standard, lawyers for everyone, better judicial training, and more transparency. That's the call to action.
That's it. It's comprehensive.
And what does Dr. Laster say happens if we don't make these changes? What's the consequence of inaction?
Well, her warning is pretty stark. She says we're essentially just replicating America's original sins.
Wow. How does she connect it?
She draws a direct line, saying we're modernizing partus sequitur ventrum, that awful historical principle tied to slavery where a child's status followed the mother's. She says we're doing that, but dressing it up with due process lip service.
And replacing the state's protective role, parens patriae.
With polished courtroom scripts that ultimately just dismiss the parents' rights. Her final plea is really powerful. Shift the burden back onto the state.
The state wants to break up a family. They need to meet the highest bar.
Exactly, because anything less, she warns, is tyranny dressed as justice.
This has been, it's really illuminated how systems, even if not designed with malice, can end up creating these deep injustices. Understanding these legal details, like Dr. Laster does, feels so critical if we actually want to protect families.
It really does. And it leaves me with the thought, maybe for you listening too, if parental rights are truly far more precious than any property right, as the Supreme Court itself said, what does it truly say about our values when the legal safeguards for those rights, like the standard of proof or access to a lawyer, are often weaker than the protections we give to, say, property disputes?
That's a powerful question.
Yeah. What's the real world cost?
Yeah.
Think about the damage to trust, to communities, to the very fabric of families when those fundamental protections feel so fragile.